Hi, and welcome to ABUS 241, Applied Business Law. I'm Melissa Brown, the instructor. Chapter 1 will provide you with the basic introduction to business law. The principles discussed in this chapter are practical. Neither these lectures, the book, or the course is a theoretical exercise. The law will affect you, regardless of your career, whether you want it to or not. The more you understand the law, the more you can use it productively. Here are two opposing thoughts on goodness. True human goodness, in all its purity and freedom, can come to the fore only when its recipient has no power. This was stated by Milan Kundera, a Czech author, in 1929. Friedrich Nietzsche, a German philosopher, stated, "What is good? All that heightens the feeling of power, the will to power, power itself in man." Most likely, you fall into one of four categories. Perhaps you're someone who does not intend law as a career, but approach the material with an open mind. Or you're someone for whom the course kindles a strong interest in the law and may for the first time consider law as a career. Or perhaps you're someone who has entered the course with a strong interest in law and plans to attend law school. Or finally, you're someone who's in the course only because the program requires it. But regardless of what category you fall into, my job is to help you see that the law is powerful, important, and fascinating, and I'll do my best on this. Our law was inherited mostly from British law. Our founding fathers created a multi-level government which guarantees our rights. It's mostly the accumulation of precedents and legal cases. It can be very frustrating to citizens and even to lawyers when the law is quite complex. Anglo-American legal history consists in part of a clash of powerful competing interests: property ownership, ethics, raw power, business practices, personal responsibility, social mores, and the need for predictability, to list a few. To understand the interplay of these forces is to understand why law is complicated. The United States Constitution establishes Congress, the presidency, and the courts. The Constitution also gives states powers not given to the federal government to guarantee our basic rights. State constitutions create executive, legislative, and judicial systems. Laws passed by federal and state governments are called statutes. Common law was created through precedent. This simply means earlier cases decided by courts. Courts may issue rulings such as injunctions to provide an equitable remedy. Administrative law is created by agencies, while the president can initiate treaties and executive orders. The common law system involves the application in current cases of principles applied in earlier cases with similar facts. Judges rely on precedent to decide on cases. If a case involves the same or similar facts as a past case, a judge can refer to this when making a ruling. Prior judicial decisions carry a great deal of weight. Binding authority refers to any primary source of law a court must follow when deciding a dispute. This includes all constitutional provisions, statutes, treaties, regulations, or ordinances that govern the issue being decided, as well as prior court decisions that constitute controlling precedent in the court's jurisdiction. In a suit against the U.S. government for breach of contract, Boris Korczak sought compensation for services he had allegedly performed for the Central Intelligence Agency from 1973 to 1980. Korczak claimed that the government had failed to pay him an annuity and other compensation required by a secret oral agreement he had made with the CIA. The federal trial courts dismissed Korczak's claim, and Korczak appealed the decision to the U.S. Court of Appeals for the Federal Circuit. At issue on appeal was whether a Supreme Court case decided in 1875, Totten versus the United States, remained the controlling precedent in this area. In Totten, the plaintiff alleged that he had formed a secret contract with President Lincoln to collect information on the Confederate Army during the Civil War. When the plaintiff sued the government for compensation for his services, the Supreme Court held that the agreement was unenforceable. According to the court, to enforce such agreements could result in the disclosure of information that might compromise or embarrass our government or cause other serious detriment to the public. In Korczak's case, the federal appellate court held that the Totten case precedent was still good law, and therefore Korczak, like the plaintiff in Totten, could not recover compensation for his services. Said the court, Totten, despite its age, is the last pronouncement on this issue by the Supreme Court. We are duty-bound to follow the law given us by the Supreme Court unless and until it is changed. Supreme Court precedents, no matter how old, remain controlling until they are overruled by a subsequent decision of the Supreme Court, by a constitutional amendment, or by congressional legislation. The law attempts to balance the need for predictability with the need for change. You may want to consider the values served by precedent in your own life and the circumstances under which a court should be free to modify or ignore precedent. For example, you may depend upon contract law to prevent a landlord from raising your rent, upon landlord-tenant law to ensure a habitable apartment, upon consumer protection law to protect you from unfair retail practices, and upon employment law to protect you from discrimination and sexual harassment. If the common law changed with every lawsuit, no one could conduct business with certainty. Laws emanating from the various primary sources of American law are enforced according to the following hierarchy. The United States Constitution takes precedence over federal statutory law, which takes precedence over a state constitution, which takes precedence over state statutory law, which takes precedent over a local ordinance, which takes precedent over administrative rules and rulings, which takes precedent over common law. In most industrial nations, no local governments wield as much power as the states do in this country. Is state government wise, in your opinion? What are some of the pros and cons of state power? Well, some pros are that the country is huge and state government keeps political power physically nearer to the people. Different geography, industry, population, and mores mean diverse concerns and opinions in different areas, and a local government can be more sensitive to these local pressures. As technology and social issues change, the law should be able to evolve more rapidly on a local level than on a national level. But some cons with this is that state borders have little meaning in an age when physical distances can be crossed quickly by plane or instantly by telecommunications. A corporation doing business in all states may have to meet 51 different sets of federal and state regulation. Another downside is that it's a waste of time for society to investigate the same issue, say liability for toxic waste, 51 times and to pass 51 different responses to the same concern.